Thousands of green card and visa applications are being denied overnight with zero warning. No second chances. No appeals. Just instant denials that erase months or years of progress. USCIS quietly activated a hard stop system in November 2025 that's turning minor paperwork mistakes into permanent case closures. And what they're not telling you is even worse. This is Immiscope, your trusted source for U.S. immigration news, policy changes, and visa updates. Right now, something unprecedented is unfolding across USCIS field offices and U.S. consulates worldwide. Internal agency memos confirmed by immigration attorneys in early November 2025 reveal new denial protocols that fundamentally change how visa and green card cases are processed. These aren't just stricter reviews. These are automatic denial triggers that slam your case shut the moment you cross certain invisible thresholds. One missed deadline, one outdated form version, one incomplete document, and your application dies instantly. No request for evidence. No notice of intent to deny. Just a final denial letter. Core issue. USCIS and the Department of State rolled out what immigration attorneys are calling hard stop restrictions. Multiple field offices and embassies began enforcing new case closure triggers that instruct officers to issue immediate denials without further warning once your application crosses specific error, timeline, or documentation thresholds. Here's what changed. Until recently, most applicants who made small mistakes, missed a supporting document, or failed to respond completely to a request for evidence could still reopen or correct their cases. Officers typically issued RFEs or notices of intent to deny, giving you 30 to 60 days to fix problems. But under the new hard stop policy effective November 1, 2025, officers are no longer required to issue second chance notices if you fail to meet updated criteria or deadlines. Once your case hits a stop condition, it's automatically denied or closed with virtually no opportunity to reopen it. According to internal updates cited by immigration attorneys, this policy is part of the Department of Homeland Security's effort to restore adjudicatory efficiency and integrity. That's bureaucratic language for faster denials with fewer safeguards. The hidden catch. Here's what nobody expected and what USCIS isn't publicly announcing. The real danger isn't just faster denials. It's that these hard stop triggers apply retroactively to cases already in progress. Families who filed petitions months ago under the old system are suddenly being judged by November 2025 standards they never knew existed. Immigration attorneys report that USCIS officers received internal guidance outlining automatic denial thresholds that include failure to respond to an RFE by the exact due date with absolutely no grace period, submitting incomplete medical exams or unsigned forms, missing initial evidence. That's now considered required at filing even if it wasn't when you submitted. Filing petitions with outdated form versions even if they were current when you mailed them. And paying incorrect fees based on old fee schedules. The National Visa Center is simultaneously enforcing parallel hard stops for immigrant visa cases abroad. NVC began issuing termination notices to applicants whose cases remain inactive or incomplete for more than 1 year. These rules existed before but were rarely enforced. Now they're being applied aggressively with zero flexibility. What makes this truly devastating is the digital enforcement system. USCIS implemented automated case management tools that flag and close cases before human officers even review the details. Your application can be denied by an algorithm before any immigration officer actually reads your story. Data trackers show a sudden spike in I-485 and I-130 denials during the last 2 weeks of October and early November 2025. Attorneys say the pattern mirrors earlier moves under the Trump administration, when USCIS adopted a no RFE policy allowing officers to deny cases without giving applicants second chances. Practical consequences. The impact is hitting family-based applicants, humanitarian petitioners, and green card renewal seekers hardest. If you rely on RFEs to fix incomplete submissions, those opportunities are vanishing. Employment-based and investor categories aren't immune either. Cases are being denied for failing to meet updated evidence formatting or digital upload requirements under USCIS's online system that many applicants don't even know about. A family-based I-130 petition missing one supporting document or a green card renewal missing proof of residence. that previously would have triggered an RFE allowing 30 to 60 days to respond now results in outright denial. Many cases are being closed automatically. At U.S. consulates in Manila, Mumbai, and Ciudad Juarez, 3 of the busiest visa posts, officers reportedly started rejecting cases that failed to meet new verification thresholds, particularly for sponsors whose income is close to the poverty line. Officers now apply stricter discretion when assessing document validity and applicant eligibility, especially under public charge and financial sponsorship rules. Solutions and action steps. Here's exactly what immigration attorneys are advising applicants to do right now to protect themselves. First, double-check every form before submission. Make absolutely sure you're using the latest USCIS form version and current fee schedule. Download forms directly from USCIS.gov on the same day you plan to submit. Even forms downloaded a month ago may now be outdated under the new system. Second, submit all required initial evidence upfront. Don't wait for USCIS to ask. This includes complete tax transcripts for the past 3 years, proof of lawful entry with I-94 records, medical exams with all required vaccinations documented, and updated I-864 affidavit of support with current income evidence. Third, respond to any RFE or notice immediately. Don't risk missing a deadline even by a single day. Under the new rules, late responses are not accepted and your case could close automatically. Set multiple reminders. Submit responses at least 5 business days before the deadline to account for mail delays. Fourth, track your case online daily. Many applicants don't realize USCIS updates its internal actions before sending physical mail. Checking your online account daily can alert you to upcoming issues in time to react. Sign up for case status text alerts and email notifications. Fifth, consider working with a licensed immigration attorney for any case filed after November 2025. The margin for error has disappeared. Professional guidance isn't optional anymore for complicated cases. Real-life scenarios. Consider the Ahmed family, who filed an I-130 family petition in August 2025. Their case sat at NVC for 14 months while they slowly gathered civil documents from their home country. In November, NVC terminated their case for inactivity with no reinstatement possible. They must start from zero. November 2025 marks a turning point in U.S. immigration processing. USCIS and the Department of State implemented hard-stop denial protocols that eliminate second chances for applicants who make even minor mistakes or miss deadlines. If you like this video, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching Immiscope. See you in the next video.